Hello, my name is Dee Dee and welcome to the latest episode of Coffee and Counsel. For more than 12 months now, home working has been the norm for a lot of employees. As lockdown restrictions begin to ease, there is perhaps an expectation on employers that they will allow employees to work more flexibly moving forwards. Those that don't or can't should expect to see an increase in flexible working requests. So what are the rules when it comes to flexible working? All employees with 26 weeks continuous service have a statutory right to apply for flexible working. To qualify for flexible working, the employee must not have previously submitted an application within the previous 12 months. The application itself must be made in writing, must contain the changes being sought and the date on which the employee proposes that it should take effect, and state whether a previous application for flexible working has been made. The request also needs to explain what the employee thinks the effect of the change will be on the employer's business and how that effect may be dealt with. Employees can request the following types of change: the hours that they are required to work, the times when they are required to work, or the place where they are required to work. You may therefore see requests for a different working pattern or to work from home all or some of the time. The default position is that if the application is accepted, it amounts to a permanent change to the employee's terms and conditions of employment. Once an employer has received a request for flexible working, they are under an obligation to deal with the application in a reasonable manner. The employer must inform the employee of its decision within 3 months or a longer period if that is agreed between the employer and the employee. Employers may have their own internal policies which provides further detail on how they will deal with applications. ACAS also have a code of practice on handling flexible working requests, which recommends arranging to talk to the employee as soon as possible after receiving their written request, unless of course the employer's intention is to simply approve the request. Discussing the employee's request with them. This should ideally be done privately and an invite sent in advance of the meeting. An employee could be accompanied by a work colleague at this discussion, but this is not a statutory right. An employer carefully looking at the benefits of the requested changes in working conditions for the employee and the business and weighing these against any adverse business impact of implementing the changes. When the employee has made their decision, they should confirm it in writing without delay. Requests can be rejected, but employers must have one or more specified reasons for doing so, and these grounds are the burden of additional costs, a detrimental effect on the ability to meet customer demand, an inability to reorganise work among existing staff or recruit additional staff, a detrimental impact on quality or performance, insufficiency of work during the periods the employee proposes to work, planned structural changes, or such other grounds as may be specified in regulations made by the Secretary of State. Employers also need to be aware that even where they are not under a duty to comply with the statutory procedure, because, for example, the employee in question has insufficient service or the request isn't in the prescribed form, there are still good reasons for giving due consideration to a request for flexible working. Employees may be making such requests due to the impact of childcare, a disability or caring responsibilities, which the employer will need to bear in mind. Employees who have asserted their right to request to work flexibly gain protection from being subjected to detrimental treatment as a result, including being selected for redundancy or otherwise dismissed. However, it isn't the case that employees have the right to work flexibly. They simply have the right to have their requests considered in accordance with the legal framework. That's why it is really important for employers to follow the correct process with flexible working requests, as an employee may complain to an employment tribunal if they consider that their employer has failed to comply with their duties, based its decision to reject the application on incorrect facts, or notify the employee that it was treating the employee's conduct as withdrawing their application in inappropriate circumstances. Each request should be dealt with on a case-by-case basis. If you are unsure as to how to deal with the upcoming changes to working practices or need support with flexible working requests or process, please do not hesitate to contact a member of the employment team at CG Professional.